talk about communicating with the carrier about developments in your case. Now, your case isn't a static claim. It's a claim that will develop over time as things change, particularly in your medical condition, or things happen in your life that they need to know about because it impacts your disability insurance claim. And let's talk about some of the things that are important for them to understand in terms of the developments of your case. But before we do that, you might be tempted to say, well, I don't want to just have an off-the-record discussion with them about this new development that's happening in my life. Look, the process from beginning to end is adversarial in nature, and the carrier plan is not in the business of being nice, paying the legitimate claims, and the sooner you understand that, the better. If they wanted to speak with you, you should be telling them that all communications should be in writing so that there is no confusion about who said what and what you were instructed to do or what they said. I find many times that the claims examiner, the nurse, or other representatives of the carrier will call you asking for information. I'm so concerned. I have questions. Bullshit. They're looking for information that they can use to deny or terminate your claim. Now, they may tell you, as I said, they're there for you. They have your best interests at heart, or talking with them can expedite the process. If you would just confirm or clarify this or that, don't believe them. None of that, in my experience, is true. So if you call them up and say, I want to have an off-the-record discussion so you can tell them about your problems with your employer, your family, your financial situation, how you're really a great person, how you're really disabled, how you would never file a claim if you could work, beware. That works both ways. Everything you say is going to be part of that claims file, and there's no such thing as an off-the-record discussion. Worse yet, I find that off-the-record discussion will be used directly against you. In fact, it could be used indirectly against you. What do I mean by that? The claims examiner can speculate about your motivation to have that off-the-record discussion. They'll even speculate whether or not your social activities that you put on your activity of daily living forms are inconsistent with the questions that they're asking you about or what you're talking about. You may say, I can't even go to my children's baseball games. And they're going to wonder, well, are you really not going, or are you going? And how long are you going? And how does that coincide with what you put on the activity of daily living form and what you said to your doctor? Even the most innocuous thing that you say or are asked about and reply to can and will be used against you. Don't think that they won't use this against you. And it gets worse because your claim is going to be reviewed by the medical provider, the disability carrier's medical in-house provider, maybe even an IME. They're going to have access to the claims examiner's notes and the speculation about your activity level, your motivation to remain disabled, your motivation to return to work. All of that speculation gets stacked, and it will influence the medical provider. I've seen medical reports where the medical provider takes that speculation and runs with it. That speculation can and will result in a claims denial or termination. And that happens in part because of your off-the-record discussions with what you told them during what you thought was an innocuous phone call, or, of course, their call asking you for information. So please don't be surprised if all of this speculation is then shared with your treating provider in an attempt to have your doctor say that the opinions they rendered in support of your claim are all based on your discussions with them and that you're not telling them the truth. So the doctor may be asked to assume the carrier or plan's speculation is true. And then your doctor is going to be asked to readdress their opinion about your treatment, your restrictions and limitations, and your ability to work. It becomes a tsunami of speculation that is going to swamp and destroy your claim. So never generally talk to the claims examiner unless it's a recorded conversation. And I'm not giving you advice about recording or not recording, because it depends on your state. Never ask them to put the questions in writing so you can respond and not on the spot. And never, ever ask for an off-the-record discussion. Now, I'm asked, do I have to tell my long-term disability carrier plan that I got a favorable or unfavorable Social Security decision? And the answer is yes, both. unfavorable and favorable decisions. Many policies or plans require that you apply for Social Security disability benefits because they have the right to reduce your long-term disability benefits by the receipt of your Social Security benefits or by that of your children. It is a legal right they have in the terms of the disability policy or plan. And guess what? You have a duty to cooperate with the carrier or the plan, and failing or refusing to give the carrier or plan a copy of that decision, favorable or unfavorable, can be a breach of the policy. That means they can deny your claim or terminate your benefits because you didn't cooperate, regardless of how disabled you might be. Is that fair? Of course not. But there's nothing fair about the long-term disability policy or plan or the claims process. So what are they going to do with that Social Security decision? Well, the U.S. Supreme Court has ruled that the disability carrier plan is not bound by the decision, but they have to consider it in making their decision as to whether they're going to pay or deny your claim. The reality is that the carrier plan will do one of two things with a decision. One, they're going to say, see, we told you that you weren't disabled. Social Security judge agreed. Or they'll cherry pick the decision and say, it's not binding on us because the Social Security Administration uses a different standard of disability. They consider age, we don't. And either way, they're going to whipsaw you with that Social Security decision. Either it supports our denial or we're going to ignore it. So what else are they going to do with that favorable decision? Well, they're immediately ask for repayment of any overpayment caused by the receipt of Social Security benefits for you and your children. They're going to reduce your future benefits by the receipt of those benefits, and it's all legal. Now, if you don't repay them, they just might sue you and ask that you be repaid. So you have to understand the consequences of this. Now, that holds true, as I said, even if there is an unfavorable decision. They will use that against you potentially. You might have gone to trial in front of a Social Security judge, and the judge has entered a favorable decision. I always argue that that's a decision they have to pay particular attention to. And if they didn't get the Social Security file, then I argue that they haven't given you a full, fair review. Now, the other reason you have to send it to them is that many times the provision in the policy says that you have a duty to continue to apply for Social Security benefits. So on the one hand, if it's a favorable decision, they want their offset. If it's an unfavorable decision, you have a duty potentially to appeal that Social Security denial. And they'll argue that you could have gotten the benefits and we're going to act as if you're getting those benefits and we're going to reduce your benefits. And by the way, because you didn't cooperate in pursuing the appeal of the Social Security decision, we're going to deny your claim based on the failure to cooperate. So you can see that they're going to try to get you coming and going. By that, I mean, if you don't send them the unfavorable decision, they can say, you've breached the policy terms. If you don't appeal the unfavorable decision, they're going to say you breached the terms of the policy of the plan. And if you got the benefits, they may very well ignore the decision, but say that they want to have their money paid back. Now, they might pay attention to the decision, but I will assure you that that is not going to be very long, because a year or 2 years from now, they may do a peer review. The definition of disability might change. And what they'll say is, hey, this decision is stale. The judge considered it. We considered it. We paid benefits, but it's no longer relevant because circumstances have changed. So be prepared for that argument. The other thing that we need to consider is that at the end of the day, there is going to potentially be a claim for an overpayment. And I have found that the timing of that will generally can coincide with the denial of a claim because of a change in condition. If that happens to you, you'll have 180 days in which to file an appeal. Before you decide to try to repay that benefits, I think that's the time to call an experienced ERISA disability attorney who will talk with you about your personal circumstances, the policy, what the decision is, the Social Security decision, whether you're going to repay the money now, whether you're going to play out the appeal, whether you're going to deal with the overpayment if they grant your benefits, and how you're going to handle that overpayment if the claim is denied and you're filing a lawsuit. Don't necessarily send that money back without consulting with an experienced ERISA disability attorney. Got it?